All right. Good morning. It is January 14th, the Senate Judiciary. We're getting an introduction from the state's attorney's office. About some ideas that they might have for the upcoming session. I see that there's some newer faces in the room. I just like getting an idea of, who everybody is. I know you, Tim, but can we just do a quick go around of folks and
Absolutely. Good morning. My name is Kim McManus. I'm the new legislative and policy attorney for the Department of State's Attorney and Sheriffs, essentially taking over Tim's position.
Good morning. I'm Tracy Patno, and I am the Director of Sheriff's Operations.
awesome. Nice to meet you.
Morning, my name's Aiden. I'm an intern with SATS and Ring.
Awesome. Nice to meet you. Yeah. So Tim, floor is yours.
Yeah, what I'll do is I'll temporarily take the chair and then I'll hand it off to Kim to talk about some of our legislative priorities. Tim Leader-Zuma, the Department of State's Attorneys and Sheriffs. And thanks for having us in first trip over here in this session, and welcome, Senator. I'll just briefly give an overview of the department and kind of what we do. And we are unique, actually, nationally in terms of what our department does as a state entity in the executive branch concerning assisting state's attorneys and sheriffs. Then I'll hand the microphone over to Kim McManus. And as you just heard, Tracy Patton is our new Director of Sheriff Operations. That position was created as a result of Act 30 for 2023 to provide more support, policy support, and really liaison support across the state for our sheriff's work. And we really appreciate the support the legislature has given us in better supporting our sheriffs across the state. So I started in my job as the executive director yesterday. I've been working at the department for the last a few years, first as a deputy and then as the legislative attorney. And upon John Campbell's retirement last week, I stepped into the role yesterday. Our department, Department of State's Attorneys and Sheriffs, I sent over some documents which are a bit voluminous on your website, but that way you have them there and I can reference them in the future, including data, overview of the department, et cetera. 175 employees roughly across the department. We serve state's attorneys and sheriffs. We serve victim advocates in the state's attorneys' offices. So we serve the 14 state's attorneys and the 14 sheriffs across 14 counties, so 28 elected officials. And we also service the grant program for the special investigation units across the state. I believe there are 12 units across
There are 12, yes.
12 units across the state. And at some point we could talk more about what that program is. But Tracy Cotton used to run the SIE program in Lamoille County. And so she has some of that background as well, which is really appreciated. The other thing that we do sort of unique, the 24 transport deputies. Conveniently, VT Digger had an article that came in maybe last night, talked about transportation of individuals, remote hearings, et cetera. And the 24 transport deputies assist people getting to court who are detained. They do that work across the whole state. And it's really an area where we could probably use some more support. And we've talked about that at another time. But we also have that group of folks in our department that are stationed in the county sheriff's offices. But they really just kind of think about it more as that group of 24. They do a lot of work across the state. We have the 72 attorneys, 14 state's attorneys, 58 deputy state's attorneys. They're averaging between 300 to 400 cases per attorney right now, which has remained pretty consistent over the last couple of years. Our 28, or I believe there's 26 victim advocates, and Amy Newton can correct me via text if I'm misstated that, but I think roughly 26 victim advocates, around 600 cases per victim advocate. And that doesn't include one case can have many victims. So they're working with a lot of people, a lot of cases right now. And then what we do in terms of the state's attorney world, criminal cases, about 99% of the criminal cases are staffed by our department. Family cases like chins, A, B, C, and D, which are different types of chins, children in need of care supervision. The family division, juvenile delinquency cases, and youthful offender cases. We also handle our own appeals. We have a central appellate staff person in our central office, Evan Enoch, who used to come over here quite a bit as a legislative attorney. And then we also staff our own post-conviction relief cases for the most part. across the state. And those are convicted individuals who's incarcerated, files post-conviction relief of some sort, different than appeal. It's in the civil division. So in some we're in criminal, we're in family, we're in civil, and we're in the Supreme Court. So we're all across our judicial landscape. And we are really a department that's spread across the landscape. We also have our central office, which is where we all work out of. And what makes us unique is that many other states will have their state's attorneys association or central office or sheriff's entity, and they're not serving both sheriffs and state's attorneys, but we do our best to serve both sides of the operation in the shop. And it really is important to us, that big picture about what we do. And if you think about, right, it's incident through sentencing in terms of the work of the department. Sheriffs are on the ground, transporting, engaging in the criminal law work that they do investigation wise, and then the prosecutors doing what they do. And on your website and also in your handouts, on the last page, you'll see a schematic that we created, that kind of criminal justice landscape schematic, fairly busy chart, but it's all on one page if you're interested. And also a slight overview of the department. Our director of labor relations and operations, Annie Noonan, really directs our budget activity. So I know there's sometimes budget work that happens in here, crosses over to appropriations. You'll see her with me tomorrow. We're actually going over to the House appropriations to talk about budget adjustment. So you will see Annie in the building quite a bit as well. And the other thing I wanted to mention, just in terms of the big picture, Kayla posted on your website some of the data that we just did, our big data extraction at the year end for December. And you'll see in there, there's 23,000 about pending cases. If that includes family, that includes PCR civil cases, that includes all the criminal cases that are pending across the 14 counties. And that results in that 300 to 400 attorney caseload as well. That does not include appeals. That's varies so greatly, but that does not include appeals. But it does 23,000 cases. A year ago, there was 26,000 pending cases. So we've actually moved about 3,000 cases. And consistently, as you'll see in our presentation in more detail, the clearance rate, meaning you file 100 cases, you dispose of 100 cases in a month, that's the clearance rate, is consistently over 100%. And that's the judiciary, judges working with us, working with the defense bar. So that's good. But in terms of if we really wanted to make more progress in terms of moving a higher number of cases, it would need to be more like 150, 200%. Meaning we're clearing more cases and we're filing to actually make headway on that backlog of residual, which is not just a result of COVID. The backlog existed before COVID. COVID made it more difficult, but we are plugging away at that work. I mean, one of the issues that I know I've talked about with the President Pro Tem is that we are so often dealing with the waves crashing over the ships that we can't get as a system, as a big picture judiciary and judicial system. We can't always keep track of older misdemeanors in terms of prioritizing those. Last year, as you'll see in the data, we had 65% more trial days were used last year as opposed to the year before. So we're having more trials. Vast majority of those trials are felonies. So that's what's making its way into an actual trial disposition, meaning our misdemeanors are getting resolved by a plea agreement. 99% of all cases are resolved by plea agreement, but it also means misdemeanors aren't making their way to trial, which is difficult because we share the courtroom. Misdemeanors and felonies share that courtroom space. And so for me personally, I will say it will be very difficult. I know we'll talk on January 23rd to move 23,000 cases. And if you look at just the active cases, which I don't like to just look at because an arrest warrant is technically inactive, but it's not inactive to us. Competency cases are inactive, but it's not inactive to us. But if you look at the active cases, it's more like 10,000. If you look at the full picture, it's 23,000. Hard to think about it just physically, hard to move 23,000 cases through 14 physical spaces from 8:30 to 4:30 with a lunch break in the middle of the day. So that's going to be our challenge as a system. I think defense, prosecution, judges, you all obviously in the executive branch in general, working together to say, how do we approach that and be creative about moving more misdemeanors? Because we file more misdemeanors than we file felonies. I just wanted to know, we have some prosecutors in our department. When you look at averages, what the thing that you lose with an average is that there are people on the way high end of that, and then people that are lower. But we have, without mentioning any names, but we had an attorney with 728 assigned cases. We're working with that attorney to see how we can peel off some of that.
Tim,
Yeah.
Senator
Oh,
Vogt.
sorry.
Yeah, nice to see you.
Good to see you, Senator. Welcome back.
Thank you. You too, in a new role. Around the misdemeanors in the backlog, has there been any sort of centralized movement to dismiss nonviolent misdemeanors that have been hanging around for 3, 4, 5 years, potentially longer than
Yeah.
a penalty would be for that misdemeanor?
Yeah, it's perhaps the paramount question in terms of the backlog about how we address that group of cases. One of our issues is we've seen Judge Maley a couple years ago up in Franklin County dismiss 300 cases using what was called Rule 48 under the Rules of Criminal Procedure. I want to, won't always be the most popular person in the room saying this, but I want to heavily encourage our judicial officers to exercise Rule 48 and look at their docket in that county with their state's attorney, with that victim population, with those defense attorneys, and say, here are the cases that we've identified as the judiciary that are meeting some of that criteria. So we wouldn't put like a domestic violence misdemeanor case in there, but we might put a DLS that's 4 years old in there where there's been no future interactions, right? Good low hanging fruit. When I was a deputy, speaking from my own experience, Judge Tebow, who was my boss at the time, was the state's attorney in Washington, had basically, I will say, Deadwood Friday. Clear out the deadwood on Fridays so that you can have a better Monday. I was given that green light from my state's attorney to do that work. And a lot of that work is happening. It doesn't make headlines a lot, but a great example, and you'll see him, I think, with me on January 23rd, is the state's attorney from Rutland. Ian Sullivan has been a complete, huge help to the department, to all the state's attorneys in terms of looking at the data statewide and helping all of his colleagues see, here are your cases that are in this category and this category. So he can talk more about that on the 23rd when we do the joint hearing. But we're, encouraging, with the limited staff that we have, encouraging state's attorneys to look back at those old cases, because we can't, people are busy. We're not going to rely on the judges to identify those cases for us. It's helpful when they do, because it then makes us act, that force action on Rule 48. Judge Tebow actually did Rule 48 in Orleans. I think Judge Treadwell did one down in Wyndham. And personally, as a executive branch person that is trying to help the 14 counties on this issue, I want to encourage those conversations with the folks that own their data. And when we do the new judge orientation with the new judges that are coming in, I'm going to emphasize, don't forget about Rule 48. Because the nice thing, the balance on that is that it does both the big picture, like here's a list of cases, but it also gives you the individual approach. Like, oh, actually in that list of 300, there's this one case, this person has a pending felony. We're not going to dismiss it right now because the sentencing's next week. We don't want to complicate what that looks like, but it's a really good question.
So as a follow-up to that, is there anything or resources, staff people that we could give you centrally to sort of help with that? Someone who could actually comb through all of those cases and then deliver them to a county to try and streamline that. Because I know I've also heard that some of that administrative work, whether it's dismissing cases, whether it's expungements, can sort of slog through the backlog. So I'm wondering if there's a way to centralize that and make it more efficient.
Yeah, so I won't call it a pilot. I did a little test in Orleans and Franklin with the permission of those two states' attorneys. And I did some of that work. And my process was, look at a case. I looked everything past 3 years. I was misdemeanor. I tried sorting it by, I didn't look for any domestics, for example, but I tried sorting it by things like disorderly conduct, DLS, unlawful mischief, that sort of community level stuff. And then I would work with the victim advocates that were assigned in those cases. And so it actually took me, I think I dismissed 30, 50 cases, and it took me 4 or 5 hours to do that kind of careful individual work. Last year in here, John Campbell, myself, and Annie, and then in the House as well, we presented this idea of docket integrity work, or basically docket management work is probably the best word. And our idea was to have essentially two individuals and maybe a centralized admin that could help with data sorting. That would be deputies that could look north and south, for example, and work with those states' attorneys and say, I've looked at your data. I've identified 200 cases that are ripe for dismissal, and then that person would maybe work with the court operations manager in those courthouses to say, instead of doing individual dismissals for each one and filing an odyssey, which I ended up doing, which ended up taking a long time. I think that what that does is that dedicated focus on the opposite end of the Excel sheet, right? The new end of the Excel sheet we're all thinking about all the time. It's in the news. It's what's happening. The old end of the Excel sheet is what would love to spend more time on, but we don't have enough staff to. So I think it's a great area to look into. And our idea was basically, I think, if I remember correctly, two DSAs that would be sworn in those counties, and then a centralized admin to help with data sorting. And it would also potentially help with things like expungement and sealing as well, which will accompany when you're dismissing a case. There's more work that happens afterwards, sealing a case, expunging a case. And so that is another piece of work that happens. The work doesn't end when you dismiss a case for our folks.
I might be mistaking it for another rule, but Rule 48 hasn't been updated in quite some time, right?
I would have to look at the notes on it. I'm not sure.
So,
And Mr. Chair, I just want to, sign on to what Senator Popowski was saying. I do think if we're going to make serious progress in the backlog, we are going to have to get more creative about this sort of thing, whether it's resourcing it or if there's some sort of statutory framework that's necessary, whether it's decriminalizing something like ELS or some other statutory move. I feel as though we're at a place where we have to admit that the speedy administration of justice is not going to be served with anything less than more dramatic moves. So I'm happy if the committee continues to hear testimony on that and potentially is poised to do something about this section.
And the last thing I was just going to briefly mention, because it's topical, is recently the Supreme Court, and I was very happy that Digger actually published this administrative order. The Supreme Court recently issued kind of an update to how we should think about backlog. And I was very appreciative of this because I think what we're talking about. I might just read that. So the original administrative order number 5 was promulgated in 1972 to promote the prompt and efficient disposition of criminal cases. The order established priorities for scheduling of criminal cases and set time periods. Basically, that's the dispositional piece that you hear about. That's what actually triggers when something is backlogged, the dispositional guidelines. So they've been doing this work for quite some time. The timeframes are discretionary, however, you do not bind trial courts. So basically, we're going to set the felonies for trial. The misdemeanors are not going to get priority. That makes sense, even though it's very frustrating if you're a downtown that's had a spate of retail thefts, and those cases are not going to trial. So just to continue, the timeframes are discretionary, however, they do not bind the trial courts. Moreover, the timeframes are not realistic, particularly for complex felony cases. In addition, the time periods are confusing and that they conflict with the dispositional guidelines for criminal cases, which are separately established by Administrative Directive 24. Therefore, Administrative Order 5 is abrogated. So this happened a couple of weeks ago. It's the Supreme Court saying, this is a bit of a reality check about how we should even be thinking about this, because the guidelines are helpful and they encourage the right behavior, but whether we can meet them is something that I think is essentially being admitted here, is we cannot meet our current guidelines for disposition. And so it is also up on your website, this administrative order number 5 update. That's really my updates from central office. Anyone have any questions about the central office or the Department of State's attorneys and sheriffs in general?
I don't have anything.
Great. I will pass the chair to my colleague, Attorney McManus, to talk about some of our big picture priorities.
Good morning, committee. Again, for the record, my name is Kim McManus. I'm the legislative and policy attorney for the Department of State's Attorneys and Sheriffs. I'm going to give you a tiny bit of background, just since we'll be spending a fair amount of time with each other in the session, so that you know who you're hearing from. I recognize a few of your faces from last year. I was the Assistant General Counsel for the Vermont Criminal Justice Council. So I appeared before you, I believe, on the sealing bill, which we'll talk about in a moment. I was there for 2 years prior to that I was a domestic violence and sexual assault prosecutor in Addison County for about 3 years. I had, out of law school, I was a public defender for 2 years in New Hampshire. I've then took quite a long break from the law, went into teaching and nonprofit work, and then came back to the law when I entered the DV world early 2020. So that's just a little bit of background for you. As Tim said, I'm here today just to review our legislative priorities with you. We submitted a number of documents to the chair that go into detail, provide background and context, and some suggested language for our priorities, which Chair, please feel free to share those with the committee as you see fit.
Copies.
Here. Those would be all the Word document attachments that were sent to
We'll
you
actually resend those just so you have them.
Great.
in one spot.
They are currently uploaded on the reports and resources page for the webpage. Yeah.
Wonderful. So again, we can dive into the details there, and we know throughout the next few weeks and months that we'll be delving into each issue, hopefully, with you in detail. But for today, I just wanted to highlight 5 of our primary areas that we're hoping we can work with you on this session. The first one is sealing. We know that you all and the House Judiciary have been working relentlessly on trying to find the right balance for our long-term criminal record keeping. The department will continue to advocate moving towards a sealing system and away from an expungement system. And we look forward to when you take that up to talking more about that. Our second priority this year is we would like to work on the definition of recidivism and create a definition for repeat violent offender. And this is primarily for better data collection. We believe the current definition of recidivism is missing a lot of our repeat offenders. The current definition is based on incarcerated time versus conviction. And so, excuse me.
Sorry, to interrupt, just informationally, I've been hearing about habitual offender. Is that different from what you're talking about, or is that the same?
That is different. Habitual offender currently, the definition is, and I would need to just double check whether it's 3 or 4 felony convictions before you're deemed a habitual offender. And then that's a sentencing enhancement. When you charge someone who has that type of record, you can add that habitual offender status again for sentencing purposes. So what we're suggesting, we wouldn't want to touch the habitual offender piece, is creating a definition for repeat violent offenders to just better collect the information of who is doing what. And are we seeing, is it a small subsection, is it larger? And we've suggested using listed crime as the triggering event to fall into that definition of repeat offender. We have some suggested language again that we've submitted that you can take an initial look at and dig into that further, but we think it'll be very helpful revising and creating those definitions for just capturing a better picture of what's occurring in our communities.
And then the last thing, would there be a different penalty? Or in other words, is it also about an enhanced penalty for that new category, or is it purely a categorization data thing?
Currently, what we're suggesting is language that would impact that data collection that occurs. There are potentially other uses for that definition, but we haven't suggested it yet.
Got it. Thank you.
Our third priority is regarding firearms. We would like Vermont's statute concerning persons prohibited from possessing a firearm to align with federal law. This would mean including persons who have been found incompetent for trial and found not guilty by reason of insanity to the list of persons who may not possess a firearm in Vermont. And again, that is the federal law, and we would like to see Vermont statute mirror that. Our fourth priority and language that we've submitted to you all is regarding driving under the influence when a death or serious bodily injury occurs due to a crash when a driver is under the influence. Our current penalty statute has there's some clarification needed about whether one can charge. Essentially, there's two people in the car crash and one person dies, and the other person has a serious bodily injury. There's language in the statute that can be interpreted as needing to choose to charge one versus the other. And we would like to clarify that a driver who causes that sort of harm is held responsible for both the death and the serious bodily injury of another. So that's just some small language changes that would clear that up. Our fifth priority is around raise the age. We are opposed to phase 2 of raise the age, which increases the age of delinquency to include 19-year-olds. We believe that just needs to be paused right now, as there are a number of issues within phase 1 that we collectively need to address. We don't think that the 18-year-olds are being properly handled within the delinquency system. And we would like to work on that before we add another age group of 19-year-olds. We look forward to speaking about that. We know that there is, we are starting to lay some groundwork about just general juvenile justice oversight next week with House Judiciary and House Human Services. And we believe that the raise the age discussion will then follow after that, and at some point circle back here. Lastly, we've heard from legislators and other stakeholders that there's an interest in continuing to examine our bail statute. We know that there's a tremendous amount of work and discussion done last year, but there seems to be an interest in looking again at the bail statute and seeing within that whether there are some solutions or at least actions that can be taken regarding repeat offenders, excuse me. And if that's something that this committee would like to discuss, our department, of course, would be interested in being part of that discussion.
And I think in response to bail, we will be having ledge counsel come in to explain when we can hold people in pretrial detention, 7553 hearings, and bail. And so I think, perhaps after we get that refresher or, introduction as to when we can and can't put people in jail prior to their conviction, I think, I think that'll be a good starting point, then we can take it from there. Yeah. Committee, any initial questions, comments?
Article.
Thank you. Thank you.
Reserve our time.
Thank you all very much.
Good to hear.
We can adjourn in a few minutes, but regarding what we've heard, a general discussion about what we want to prioritize. Anything that we want to take?
Well, when we had the legislative day at Franklin Canal, Chris was there. I brought that exact question to Judge Miller in there as far as we have a serious docking problem here in Franklin Canal. We want to look at an avenue to look at. So just like Robowski said, getting rid of some of the docking here. It's like that in the DLSs, anything that has to do with misdemeanor offenses, motor vehicle offenses, where there's no victims, there's no restitution along those lines, and say, or 3 years or older. Those are the things that we should seriously look at implementing, or at least talking about that.
Yeah, last I heard, our speedy trial statutes and rules have not been updated in quite some time. And I think that, we could definitely find a place where there's an agreement where, something is a 5 or 6 year old license suspension, is that something that really needs to continue lingering on the docket and taking up space in everybody's time? So, yeah, definitely. That. What is?
To raise the age question, is gonna come back. We've seen it now. The continuing members of the committee have seen it multiple years. We've delayed multiple times. I noted that the reasoning that we were offered here was different than the reasoning we've heard from the administration. We did have a report last year that the first stage of raise the age was going well. So I'd be interested in looking into that disparity. They seem to be reporting that there were problems with phase one, but I think it was I forget the organization's name that gave us the
I remember what you.
crime services.
CRG, yeah.
CRD.
Crime research. Yeah.
Crime researcher. They gave us a very positive report on phase one. And that was partly what our discussion was based on last year. So as a first step, trying to resolve, I guess, which is true. Is phase one going well, or is it problematic? But we're obviously headed toward that same discussion about what sort of ceiling constitutes an effective seal that approximates expungement. And what just kind of makes a mockery of expungement.
Yes. Regarding raise the age, the House is beginning that bill. And you know, from what I've heard is, they're trying to come at it from a different angle in a way that is compromise between different perspectives that we've heard. So that's all I've got for the House, but we'll see what they send us in the future. And regarding sealing and expungement, I think there's a lot there that needs to be done. We will be getting the bill soon. I did put one in. Ironically, I've largely heard from defense attorneys that find our current sealing and expungement system very strange and also problematic. So for the same prosecutors as well, but it's going to be a lengthy conversation regarding sealing and expungement.
And probably worth noting that Senator Sears worked multiple years. And I think of him as somebody who had exceptional ties with all the people involved, and he found it difficult to come to a solution on that one. So, some of the things that they wanted seem to be relatively easy, but others are impacted problems that have been passed down to this
Yeah,
session.
with sealing and expungement, I do have one possible alternative that will kind of rethink the system a bit in a way that's fair and balanced to both sides of the courtroom. So, but we'll get the overview from the bill that was passed last year, figure out how we want to proceed, and then take it from there.
I did have one question. I don't know if it was executive director or Attorney McManus that brought it up. I believe CRG on the Joint Legislative Oversight Committee also brought up the definition needed to be changed, or requesting recidivism be changed because it only included incarcerated individuals. So my question is, who changes that definition?
I suspect that would be those two. Okay.
Be Judiciary?
Unless I hear otherwise. But
Well, we still need some advice on that.
yeah. I'll just check which statute it's high in. But I mean, it's in our jurisdiction, so. Great. Any other thoughts, questions?
I'm just soaked it all in, yeah.
There'll be plenty of healthy conversations in reference to raise the age, sealing and expungement, along with many other things that you'll find. Someone interesting in here.
Tomorrow's going to be very exciting. We'll be hearing about properties, trusts, and automobile insurance.
Oh, excellent.
Yeah.
Didn't we deal with that last year?
Yeah, I know that house.
It didn't make it all the way.
Oh,
Yeah.
Darby Dick. Senator Sears bringing his automobile policy and.
He was never shy about advertising his personal connections to the issue.
Yeah.
I remember when it was, strict liability, he kept pointing out that, Senator Bain was an example of it, and that he was a member of the class that was suing Senator Bain. So he was always willing to put himself on the record that way.
But I believe that came out of here unanimously.
Yeah.
Yeah.
Okay.
Yeah.
So we're reintroducing what passed out unanimously, not that I remember, so we'll be hearing from the same witnesses as last time, and hopefully it'll be pretty straightforward.
Yeah.
Great.